Good afternoon, everyone. Thank you so much for joining us. We'll give folks just a couple minutes to log on. I'm Allie Gold-Roberts, the Senior Director of the State Policy Team here at Ceres, and I am thrilled to be moderating this afternoon's webinar, A Guide for Businesses, California's New Climate Disclosure Legislation. And I'm just going to go over a few housekeeping items, and then we will dive right in. We can jump to the next slide in just a moment here. As Ceres has some antitrust guidelines that we wanted to just put up for folks. So we'll just give everybody a moment to read these. And if you have any questions, please feel free to chat us directly, privately, or put something in the Q&A. But this is guidance that we put up ahead of all of our meetings. And with that, we can jump to the next slide. And it is my pleasure to really just kick off this discussion. As many folks know, a month ago, California set a national standard for corporate climate disclosures when Governor Gavin Newsom signed two landmark climate bills into law. These two bills are the Climate Corporate Data Accountability Act, SB 253 by Senator Scott Wiener, and the Climate-Related Financial Disclosure Risk Disclosure Act, SB 261 by Senator Henry Stern. Together, these two bills will require corporate emissions data and climate-related risk disclosures from large companies across the U.S. SB 253 and 261 cover public and private companies and will serve as critical complements to the pending U.S. Securities and Exchange Commission climate disclosure rule, which will only apply to publicly traded companies. As a longtime supporter of corporate climate disclosure requirements, Ceres was honored to be a co-sponsor of both SB 253 and 261 this session. And we applaud the California legislature and, of course, Governor Newsom's leadership in passing and signing both bills into law. These policies, of course, continues California's role as a national and global economic leader by requiring standardized and consistent climate transparency requirements here in the U.S. With that, let's jump to the next slide, and you'll see that really Ceres, our role was in rallying company and investor support for these bills. More than 30 companies, institutions, and industry groups publicly advocated for one or both of the bills, and many privately engaged with us as well, demonstrating significant corporate support for standardized and consistent reporting requirements. Companies including Microsoft, Sierra Nevada, Adobe, IKEA, Palo Alto Networks, REI Co-op, and many others. And of course, Salesforce, Apple, and Google issued their own statements in support of SB 253, as did clothing industry groups like the American Apparel and Footwear Association, who we'll hear from in just a little bit. So we know there are a lot of questions still from the corporate community, and that is the goal of this webinar. To kick things off, we can just walk through the agenda on the next slide. You'll hear directly from California Senators Henry Stern and Scott Wiener, the authors of both SB 253 and 261, about the significance of these policies and, of course, their thoughts on the upcoming implementation process. We'll be pleased to welcome Chelsea Murtha, the Sustainability Director with the American Apparel and Footwear Association, to share their perspective on SB 253. And for the final half of the webinar, our Ceres experts and my amazing colleagues will share a detailed technical overview of both bills, how they compare and harmonize with the pending SEC regulation and other emerging global requirements. We'll also cover the next steps for both bills, as both bills will require the California Air Resources Board, better known as CARB, to create and promulgate regulations. And as some of you may have seen, Governor Newsom released signing messages for each bill when he signed them into law earlier this month, noting some concerns about the implementation timelines and potential fiscal costs to companies covered by each regulation. We look forward to working with CARB and the Newsom administration to ensure that both bills go into effect as signed into law and on schedule. And finally, we'll wrap things up with time for Q&A. We've collected questions through the registration process, and thank you to many of you who have already submitted questions. I hope we'll be able to get to all of them, but we also encourage you to share questions directly in the chat. Please add your name and organization to your Zoom name with the 3 dots in the right-hand corner before posing a question, just so we have record of who the question is coming from. And with that, it is my great pleasure to introduce both Senator Henry Stern and Senator Scott Wiener, who I had the great pleasure of finally getting to meet during New York Climate Week. Their incredible leadership made the passage and signing of both of these possible, and we have been so honored at Ceres to get to work with them. Senator Stern represents the California State Senate District 27 from Los Angeles to Ventura County, and Senator Weiner represents District 11, which includes all of San Francisco. Both senators are major climate leaders, and their work on SB 253 and 261 creates a larger national and global legacy. So with that, right off the bat, first of all, thank you both for joining us. We are so grateful for your leadership. And we know it's taken 3 years to get to this point. What is the significance of California's passage of 253 and 261, and of course, the state's leadership on climate disclosure? And since Senator Stern, you've unmuted first, you get, I think, the chance to speak first.
I'll speak first and try to be brief. Looking forward to the discussion today, and thank you to Ceres for putting this together. I think we'll finally be able to unfreeze and hopefully unlock a lot of capital that's sitting on the sidelines, that's been bullied and scared into a place where folks are uncomfortable now investing or even looking at ESG principles. They feel like that freedom to invest has been restricted either by threats of boycotts in other state legislatures across the country, like Texas and West Virginia, Kentucky, and Florida, or in light of the inaction at SEC, which we're all waiting for. It feels that things are at a stasis and sort of frozen, at least in the US economy, while Europe, UK, Japan, Canada, all sort of charge ahead and get the upper hand, if you will, in this sort of sustainability focused space. So while the House GOP and others may be sort of focused on hunting for anyone out there who would dare to take a corporate leadership role, we're actually looking for corporate leaders. And we're hoping that they can help us not just get the bills implemented, but done ahead of schedule. There's a lot of leadership. So that's within your ranks. We look at you, Ceres, as our hub of that leadership. So really do appreciate it.
Thank you, Senator Stern. Senator Weiner.
Hi, thank you for having me, and big thanks to Ceres for co-sponsoring these bills and for being really great coalition partners and getting them across the finish line. It's a huge win for California and frankly nationally and internationally in terms of climate action. I agree with everything that Senator Stern said, and this is a really important way for California to push back, to adopt good policy and then push back against the climate denier forces that currently control the House of Representatives and the red states that are trying to just outrageously prevent corporations from even voluntarily choosing to be sustainable. It's really outrageous, and California needs to move in the other direction. And we have a long history of leading the way nationally and internationally, whether it's our California tailpipe emission standards going back 50 years, the work we've done around expanding and investing in clean energy, and a number of other first of their kind, groundbreaking environmental and climate policies that California needs to remain in the lead, and we're doing so with these now laws.
Fantastic. What was the role of the corporate community in really helping achieve passage of these bills, whether that was feedback on the language to get us to the final bills, but also in really hopefully demonstrating the feasibility of disclosure and, of course, the need for a level playing field?
The corporate support was really critical, and with SB 253, it was a 3-year process, including last year when we died on the assembly floor with 40 votes, just one vote shy of the 41 we needed. And we've always had some level of corporate support. Companies like Patagonia and Dignity and some others, but it was one of the things that helped us and really made a difference this year was just expanding corporate support. When Ceres came on as a co-sponsor, when we started getting some really large corporations like Microsoft and Salesforce, and at the last minute, which was very impactful, Apple and Google, and Amalgamated Bank and so forth. It just made a big difference because especially we had, I've done a lot of tough bills where there's been misinformation on the other side. I've never seen this level of misinformation from the opposition. The things that they were saying, that my colleagues would come to me and say, the Chamber of Commerce or whatever group said this, and I'd be like, what? That is just literally just made up. And we would have to constantly correct the record. But one of the things they would say is that they would, like, this is somehow like something new, which it wasn't. We weren't creating anything new. This is all existing standards. They would say that it's going to be impossible to implement or so onerous or so expensive. And the answer is no, that's not true. And the fact that we had so many corporations that were already doing this and saying that this should be a requirement to level the playing field, that was a very powerful response to some of the statements we were hearing from the opposition.
Senator Stern, anything you want to add there?
The only thing I would just add is just getting fluent in, when we look at issues, technical issues like Scope 3 emissions, the diversity of your membership and understanding, what the difference is for a Best Buy versus an Amazon versus a General Mills versus a McDonald's, and what those sort of big material core pieces are of their either risk portfolio or of their sort of Scope 3 sets that we think will be really important in driving the marketplace. So I think, it's hopefully us getting fluent in their challenges too, and finding a sweet spot here where we can charge ahead early. And that's what felt to me was happening at the end, is that corporations weren't just sort of leading and getting a bill done, but now let's get a stable and safe regulatory framework in place so we can actually move forward.
Well, that's a perfect pivot to this last question. Just your kind of thoughts and encouragement for the companies who will be covered entities on the next steps, clarity for them about the role that the legislature will play, and how they can be best engaged. And of course, Sarah and Jake on our team will cover how they can do that with Ceres help and support. But your perspective on thinking about this from engagement in Sacramento, I think would be incredibly valuable.
Well, I think I've learned over time, sometimes the hard way, that passing a bill and getting it signed into law, as difficult as it is only the first step. You have to make sure your bill is being implemented and being implemented well and consistently with the language of the law and what the legislature intended. And so here there are two things. First of all, I imagine there will be some sort of legislative effort next year to potentially undermine, particularly SB 253, and we will not allow that. We will do everything in our power to prevent that from happening. The governor had made sort of a vague comment about cleanup legislation. We're waiting to hear what he means by that. If it's true cleanup legislation, happy to have that conversation. Of course, the Chamber of Commerce immediately glommed on and said, "Oh, we're going to focus on cleanup legislation," which for them means, blowing up the law and making it, meaningless. So we're going to all have to be very, very pay close attention next year to make sure that any effort to undermine this or both laws is met with a lot of pushback. In addition, CARB has a significant role, the California Air Resources Board, in implementing the law and setting regulations around it. We need to be very engaged in that regulatory process to make sure that the bill does not get damaged in its implementation. So those are two areas where people hopefully will be very engaged.
And the only thing I would add there is, to crystallize those action items, it's engagement, I think, within Ceres, but also in the chamber itself. And those of you who are big members of the chamber, not letting the petroleum industry set the tone there and sort of drive the conversation, but actually engaging in that process and saying, I don't know if we want to get into a decade of sort of legislative attacks or litigation. And instead, why don't we sort of embrace this and work with this? So I think inside out will very much help. And then I think engaging with this administration and bringing to them some concrete steps on implementation in the near term, so that whether or not we need to tinker at all around some technical issues in the legislation is one thing, but I think it's actually the regulatory framework and asking the governor to budget in his January budget with CARB to put a line item in that budget to help get this process moving. And I think we should be rewarding, in my view, early actors, people who want to submit ahead of schedule, people who want to build a framework to get this work done even ahead of 2027. That's the kind of stuff that, to me, is very constructive to engage now through Ceres with CARB and really show the governor's office, like, you've been getting a lot of stuff in your ear. We get that, but there's actually a really pro-growth, kind of pro-corporate path here that we can still stay aligned with climate leadership goals.
Fantastic. And I think that really aligns with, of course, the longstanding cries we've heard from businesses for policy certainty. So we really appreciate those comments and that early action and engagement. And our team will be addressing that in the second half of the webinar. So I know both senators, you're busy. It's Halloween. You probably have to go meet with constituents and give out candy, which is very important. But thank you so much for joining us. Thank you for your leadership and your collaboration with Ceres. And we look forward to continuing to partner with you in ensuring that the letter of the law is what we see moving forward. So thank you again for your time. And with that, let me introduce Chelsea Murtha, the Director of Sustainability with the American Apparel and Footwear Association, or AAFA. AAFA is the leading trade association for American apparel and footwear brands, representing more than 1,000 world-famous name brands, retailers, and manufacturers, many of whom are members of Ceres, either our policy network BICEP or our company network. So we're thrilled to have you here, Chelsea, and so grateful that so many of our members really worked with you and the association to engage in particular on SB 253. So thank you for joining us, and I hope you can tell us a little bit about why AAFA took a support position and how the bill really aligns with your members' priorities.
Right. Well, thanks, Allie. Yeah, we were really grateful to be able to come out in support of SB 253 earlier this year. And the process really started actually with us kind of initially looking at the SEC proposal and doing kind of a scoping exercise among our membership of kind of what was possible and what we'd like to see happen. And, nobody knows where exactly the SEC is. But in addition, we had a lot of conversations in the membership about where we should be on policy that actually enables the industry to become more sustainable. And to that effect, we put out something called our Threads protocol earlier this year, where we listed the things that we thought legislation needed to have as kind of a high level general principles for us to support. And it's things like it's harmonized, it's science-based, the timelines are realistic. And we used that framework when talking with you, the folks at Ceres and Senator Wiener's staff, to really make sure that this bill was in a place where we thought we as the industry could get there and support our members getting there. Language tweaks were, I think, actually relatively easy to work through. We made our cases, some things made sense. We were able to find adjustments here and there that worked for our members. And so we were really happy to be able to come out and support this. And we do think this is going to help kind of set a floor and help the industry move forward on emissions disclosure.
Fantastic. Well, that really wonderful criteria that you outlined perfectly describes these bills. So I'm so glad that you were able to utilize it to get to a support position. In that vein, what are the benefits that the bills will create for your members' current and future disclosure practices?
Right. Well, one of the key benefits I think that my members saw in this bill is that there's language in there pointing towards international harmonization, right? So, the ability to use, if we get an SEC rule that's substantially similar, use the reporting to the SEC to meet the requirements here, potentially using reporting under the EU CSRD to meet requirements here, and just looking at frameworks like CDP. These are all things that my members are looking at really closely, that they're using already. And the idea that this kind of standardizes the expectations was really, really appealing to my membership, because they are all driving work here and they're all trying to get things done, and having a clear expectation and framework was important to us going forward.
Fantastic. And how are members already starting to prepare to report? In particular, as Senator Stern said, they're thinking about who can even start submitting early. And we know that some companies already voluntarily do a lot of this work. So what's the preparation work that's happening underway within your membership?
Right. Well, I want to be clear. I mean, as the apparel industry, there is a lot of work for us to do. We are sort of the end buyers of a lot of products. We buy raw cotton, we use plastic, we use metals. This is we're at the very end kind of the supply chain, putting together a finished product. And for us, and another appeal of this bill was that this makes everyone have to engage in the process. We need people at the raw material level to be working on reporting so that we can do our own reporting. And it's a lot easier to have these conversations with suppliers outside the United States if this is just a basic expectation of doing business. And so to that effect, like on AAFA's behalf, am actually flying to Cambodia and Vietnam at the end of the week to talk to suppliers about these requirements and these expectations. And we're, working with organizations like the Apparel Impact Institute and the Fashion Pact, and looking at ways that we can help our suppliers reduce their emissions and also get better at reporting on them, with the goal towards actually helping our members overall reduce emissions, not just report on them.
Fantastic. Well, Chelsea, you've got your work cut out for you, and I know you're about to be hitting the road. So thank you for squeezing in a few minutes to speak to our audience, and we look forward to partnering with you and your members in the months and weeks and years to come on how we make these bills a reality, and thrilled that you're already thinking about that engagement with your supply chain. So thank you for your leadership and collaboration. Yeah. Fantastic. Well, with that, it is my great pleasure to introduce my colleague, who I think everybody on this webinar probably already knows, my amazing colleague, Ceres, who is our California Policy Manager. She's going to lead us in a deep dive on both bills. Many of you know Sarah led our work on both bills in Sacramento and has been working with us for 3 years as we really work to get to this important point. And as we move into the implementation, Sarah will continue to lead our engagement on the future legislative development front and engagement with the administration in partnership with my colleague Jake, who will be doing so on the CARB engagement front. So we'll have a tag team presentation from both Sarah and Jake. So Sarah, let you take it away.
Thank you so much, Allie, and hi, everyone. It's great to see you. As Allie mentioned, I have been leading a lot of Ceres' work on these bills over the last couple of years and know them pretty well. So wanted to really take this time. We've gotten a lot of questions about the exact nuance of both of these bills. So I'll do my best to pack in a lot of information and very text-heavy slides over the next minutes. But do want to emphasize we will share these slides afterwards. We also will share a detailed fact sheet that goes into each of these bills. So just going in numerical order, I want to kick things off with 253, which is the emissions disclosure bill. So as a quick moment,
your audio is a little hard to hear, so if you don't mind speaking up just a little bit.
Absolutely.
There we go. Am I coming through more clearly?
Much better. Thank you, Sarah.
Great. 3 years in, you'd think we'd figured out microphones, so forgive me. But yes, diving back in, SB 253, so this is the emissions disclosure bill, really focusing on companies that do business within the state of California above $1 billion in annual revenue, who need to report on their complete greenhouse gas emissions profile, so scopes 1, 2, and 3. And those reports need to go to a third-party emissions reporting organization, which will be contracted by CARB, the Air Resources Board. This data, you'll hear this term used a lot, doing business in California. We've gotten a lot of questions about that, so I will go into detail later on in this webinar. But I want to note that this bill is estimated to apply to about 5,000 both US and multinational companies. Due to the expansiveness of this terminology, doing business in the state, we expect it to apply to most companies above that $1 billion annual threshold. So a pretty expansive list. I really want to give a huge amount of credit to Senator Weiner. He and his team made a huge amount of effort to ensure that California was not reinventing the wheel with this bill and was actually creating a standard that was aligned with broader global best practices around emissions disclosure. And this is why the bill identifies the GHG protocol, which is the most widely used global framework for emissions disclosures, to be used under this bill. And with that, we've gotten some questions around whether folks will need to report just California emissions or global emissions based on the GHG protocol framework. Anyone covered by this regulation will report their full global emissions to the state of California. They will not need to separate out those state-specific emissions. It's very much focused on that broader global conversation. So these emissions will also need to be verified by a third-party assurance provider. Scope 1 and 2 data will begin at a limited assurance level in 2026 and will then be required at a reasonable assurance level in 2030. For Scope 3 emissions, we will have the Air Resources Board assessing trends in assurance requirements, and they will then set an assurance requirement for those emissions by January 1st, 2027. We then expect assurance for Scope 3 emissions to be required at a limited level beginning in 2030. And finally, for the timeline, as you've heard both senators refer to, there will be this implementation process through the Air Resources Board in which they will set the exact timelines for this data to be due to the state. For Scope 1 and 2 emissions data, though, we do know it will be required beginning in 2026, with Scope 3 emissions staggered to begin a year later in 2027. Going to our next slide, I want to get into a little greater detail about other elements of this bill. So one key element to really ensure that the state has the funding necessary to pursue the administrative and implementation process, anyone covered by this bill will be required to submit an annual filing fee. This amount is not specified in the bill. CARB will set that fee at an amount that is sufficient to cover the costs necessary to implement and administer the requirements of the bill, with the total amount not exceeding actual and reasonable costs required. However, there was earlier estimates made that this could be anywhere from $1,000 to $1,500 annually. So we don't expect it to be a bank-breaking amount for the companies that are covered. Another key element highlighted in the bill is the use of administrative penalties. So CARB, as a part of the regulatory process, will develop regulations that authorize it to seek administrative penalties for non-filing, late filing, or other failure to meet the requirements of this bill. And I want to emphasize this is different from a civil penalty, which is sought by the state attorney general. Instead, this is really focused on ensuring that companies are providing the data that they're required to under this regulation. Again, want to give a huge just moment of shout out to Senator Weiner and his team for really thoughtfully thinking through the complexity of this penalty process, really making sure that it would not unnecessarily penalize anyone who is making the most effort possible to provide this data on a good faith measure. So that's why there is a cap fee. So administrative penalties may not exceed $500,000 in any reporting year. There's also a specific good faith consideration, along with what we're calling a Scope 3 safe harbor, which specifies that any covered entity will not be subjected to an administrative penalty for any Scope 3 data misstatements made under a reasonable basis and disclosed in good faith. Similarly, there's an on-ramp for Scope 3 penalties. So for the first 3 years of reporting under this regulation, penalties for Scope 3 data will only occur for non-filing. The final element I want to emphasize about SB 253, again, really just huge props to Senator Weiner for thoughtfully thinking this through, is just looking at the larger global landscape. We know there's been a lot of evolution in the last couple of years around changes to disclosing processes and best practices. So as a part of that, there is a provision that enables an assessment of global emissions reporting best practices starting in 2033 and every 5 years thereafter. CARB will seek input from stakeholders to make sure that SB 253 is consistent with larger global best practices with emissions reporting. So now I'll pivot to SB 261. There's a lot of, going to the next slide, a lot of similarities between the two bills. This bill also covers companies that do business within the state of California, but this is a complementary bill, is more focused on climate-related financial risk disclosures. And it also covers companies that are at least above 500 million in annual revenue. And these reports would be required on a biennial basis, so every 2 years, as opposed to the annual report required by SB 253. Another key difference is given the much smaller revenue threshold and just the larger universe of companies that are covered, the state will not require entities to submit those reports to the state. Instead, this regulation will require covered companies to just make those reports publicly available, which could be in financial documents, via a CDP report, or as a part of sustainability annual reports that are made publicly available on websites. So really a key differentiator between these two bills. Again, as I noted, we expect a much larger universe of companies to be covered, likely around 10,000 companies, again, including both publicly and privately held entities. Similar to SB 253, SB 261 leans into this global framework. So the TCFD framework, or the Task Force on Climate-Related Financial Disclosures, which, like the GHG Protocol, is the globally leading framework being used for climate-related risk disclosures. It's being considered by the SEC for their pending climate change disclosure rule, and is also already integrated within CDP's climate change questionnaire. And another similarity between the two bills, reporting for SB 261 will also begin in 2026. Going to the next slide, there's a lot of similar information. As I noted, both bills are pretty well integrated with a lot of their technicalities. So there's a similar filing fee. I should have noted it's not annual, it's actually biennial, for the reporting year upon which companies are submitting and making publicly available those reports. There are also administrative penalties for SB 261 as well. The fee cap is a little bit lower. It's $50,000 per reporting year versus the $500,000 amount specified in SB 253. But there's a similar good faith consideration that is incorporated with pretty similar language to SB 253. And finally, just as with 253, 261 requires the California Air Resources Board to contract with what they call a third-party climate reporting organization who will take on the bulk of the implementation work required by this bill. For SB 261, there are 3 key actions that this reporting entity will take on. That includes a biennial summary report, so every 2 years, taking the information that has been made publicly available on corporate climate risk and summarizing that within this summary report. Another key action they'll take on is working with key stakeholders to ensure that, again, the practices of climate risk disclosures are consistent with global best practices, so that this requirement in the state of California is staying consistent with what we're seeing across the global reporting landscape. And finally, there's a provision requiring this third-party entity to monitor any federal actions within the United States to make sure that reporting is consistent with any actions that is happening within the federal government. So with that, I want to move to the next slide and revisit this term, doing business in California, which I keep using. And I think the important emphasis is that this isn't a term that came out of nowhere. It's actually a legally set term within the state of California. In fact, California's revenue and taxation code law defines doing business in California as qualifying under these 3 provisions. So that includes engaging in any transaction for the purpose of financial gain within the state, being organized or commercially domiciled within the state, or having California sales, property, or payroll exceed these amounts, which are updated every year by the state on their website. So we expect CARB to lean into this definition through the regulatory process. But because of this, this is why I noted we expect most companies operating within the US or multinationals to be covered by these regulations if you're over $1 billion or 500 in annual revenue. Given that California is the 5th largest economy in the world, it's pretty likely that most major companies would be covered by these regulations. And finally, I want to just note one additional provision which Chelsea highlighted in her comments. If we move to the next slide, both bills have provisions that really aim to reduce duplicative reporting. Again, Senator Stern and Senator Weiner were highly attentive to concerns from corporations regarding, having just one more regulation that has to be taken on, or one more set of reporting recommendations that they might need to do within the state of California. So both bills have these provisions specifying that if a covered entity is providing the information required under these bills, either for another country, for the United States government, or in the case of SB 261, if you're supplying this voluntarily, such as under the CDP Climate Change Questionnaire, you can just take that report and have that, in the case of SB 253, submitted to the state, or in the case of SB 261, if that report is publicly available on your website, you'll be in compliance with the state of California. So I included the exact definition within each bill on this slide, so you can read through it if you're interested. But I think the keynote there really is, the goal of this is to reduce any duplicative reporting that you all might feel like you might have to undertake. So with that, again, there's a lot of detail within these bills. I tried to get through as much as I could within a limited time, but I know my colleague dropped our much longer fact sheet within the chat, which I encourage you to look over. And our Ceres team is also happy to hop on a call and talk through both bills in much greater detail. So Ali, I'll turn it back over to you.
Thanks so much, Sarah. It is my pleasure now to introduce Jake Raskoff, the Director of Climate Financial Regulation with the Ceres Accelerator for Sustainable Capital Markets. In his role, Jake has primarily been focused on federal accounting of climate risk, but he'll also lead Ceres engagement with CARB's implementation process of SB 253 and SB 261 in the coming months. Jake, it's a pleasure to welcome you to the California Policy Team.
Thank you so much, Ali, and thank you, Sarah. So if we could go to the next slide here, my goal is to kind of put these groundbreaking California laws into the broader context of what's being considered at the federal level here with the SEC, and then also what's underway in Europe already with their Corporate Sustainability Reporting Directive, or CSRD. So I do not want to diminish the fact that the California laws are crucial, first of their kind, mandatory disclosure standards in the United States, the likes of which we have never seen. We're in a holding pattern awaiting a final SEC rule, so the California bills are all the more important right now, and we really applaud the leadership from California. But it's important to note that the California laws do complement but do not negate the need for mandatory SEC disclosure. So I just want to sort of take a step back and ask, why was the SEC rule proposed? The way that climate disclosure currently works is that in 2010, the SEC put out interpretive guidance, basically telling companies that if certain climate risks are material, that they should disclose them. That 2010 guidance has largely failed to work. There is no consistent and comparable disclosure from SEC registrants, which are, for the most part, publicly traded companies with a listing on NASDAQ or New York Stock Exchange. So, investors look to SEC filings like annual reports Form 10K or, an IPO perspectives Form S1 to get all the information they need to make capital allocation and investment stewardship decisions. And what the SEC has proposed here is really a consistent, comparable, and investor-grade framework for all SEC registrants to disclose the same sort of information on climate risks so that an investor can then go into a company's 10K and compare its climate risk disclosures to those of its peers. So it's really crucial, and everything the SEC proposed is very much through the lens of financial materiality for the most part. Basically, how are climate risks impacting companies, operational and financial well-being? SEC Chair Gensler has said repeatedly the commission has zero climate policy-making role whatsoever, and this is really just about providing investors with consistent, comparable, decision-useful information. So California's laws were designed to provide this information not only for investors but for a broad range of stakeholders. But I think that the investing public still really needs this information in the same place that they get audited financials, risk factors, MD&A, everything else, and that's why it's so important that the SEC move forward to finalize and adopt their rule. But generally speaking, we're going to see climate-related disclosures move out of sustainability or corporate social responsibility reports and into legal documents like SEC filings or like the filings contemplated with the California laws. So companies are going to need to embed their climate disclosure strategy into multiple business units, and the move towards mandatory reporting brings with it potential exposure to liability risk in the case of the SEC or civil penalties in the case of California. But just the general trend here is that the stakes are raised for companies that have never had to supply this sort of information anywhere other than a voluntary sustainability report. This now takes on the same sort of weight and scrutiny within a company that a financial filing does. So that's really the importance of the global trend here. Sarah has done a great job of discussing the intricacies of the California laws, but I think, one high level thing to note is that the California laws and the SEC proposed rule are both informed by the same common language, which is the TCFD framework for climate-related risk and opportunity disclosure, and then the greenhouse gas protocol for scope 1 through 3 emissions disclosure. And this is also, generally speaking, what underlies the EU CSRD. So there is a common vocabulary across all of these mandatory disclosure frameworks. Of course, the details differ slightly. If a company is in compliance with the California disclosure laws, both of them, they are a significant way towards being in compliance with what the SEC has proposed. There are certain, distinct elements of the SEC rule because it is, within financial filings and for the benefit of investors. I think the most notable example is that the SEC has proposed, a footnote to audited financial statements calling out where climate-related metrics have moved any individual financial statement line item 1% in either direction. So companies can explain how climate risks and metrics are actually flowing through the audited financial statements. But in terms of scope 1 through 3 emissions disclosure, TCFD aligned risk reporting, assurance of emissions reporting, there's great alignment between California and the SEC. And I think if the commission moves forward and finalizes something that looks close to what they proposed about 18 months ago, then we have good hope for harmonization and the ability of companies that are publicly traded and disclose this information to the SEC to enjoy some form of, substituted compliance in California. So again, these are complementary standards, but, neither one can stand alone in isolation. So I'll move to the next slide here and just go into a little bit further detail on where the SEC stands, because I know that's top of mind for a lot of companies. There's a question of what the SEC rulemaking does and does not do in terms of the influence these California laws might have on it. Some of our fellow NGOs, including Americans for Financial Reform, Public Citizen, and Sierra Club, commissioned a study that was just out this past week on the overlap between SEC disclosure and the California laws. This is a really hazy subject area because the California laws do implicate public and private companies. So it's harder to get that revenue data on private companies. But if you start with the universe of SEC registrants, you can then apply a revenue filter and kind of see the overlap. And so this study looked at the Fortune 1000, which is a good proxy for the largest publicly traded companies, and found that at least 75% of them are covered by SB 253, the emissions disclosure law, and then slightly less are covered by both bills. And that's because insurance companies are exempt from the TCFD reporting bill, SB 261. But generally speaking, about 3/4 of large SEC registrants are covered by California. So what does that mean? I think it can definitely meaningfully move the SEC's economic baseline when they're doing a cost-benefit analysis of the compliance costs associated with their disclosure regime, right? So if 75% of registrants are already making these reports in California, that should really reduce the compliance costs associated with the SEC rule. What it doesn't do, I don't think necessarily, is change the SEC's kind of unique calculus around what makes the final rule. And so that's where I discuss key outstanding questions. One is emissions disclosure. The SEC received the most comments in the file for this climate disclosure proposal of any rulemaking in the agency's history, about 16,000 public comments. And there were a lot of points that the registrants and investors and public stakeholders had to make about the rule, but definitely the most controversial provision in this is scope 3 emissions disclosure. That is because the SEC's statutory mandate is disclosure from publicly traded companies. That has largely been the trade-off of going public as a company, is you need to make SEC filings. And scope 3 reporting, the SEC included a lot of flexibility in its proposed rule about companies' ability to rely on estimates and averages. But it is ultimately at the discretion of the reporting company whether to, request more granular data from suppliers and other counterparties in their value chain. And so that, opponents of the rule argue that that bumps up against the limits of the SEC statutory authority. And so that is one place where the burden on potential, non-registrants, that's the only place that really shows up. And it's the reason it's the most controversial aspect. And then there is, as I mentioned, that, regulation SX financial statement footnote disclosure of climate metrics. I think the controversy around that is a little bit more technical, and, whether companies can instead rely on a more traditional understanding of financial materiality versus the so-called bright line threshold of, if any one line item moves by a certain percent in either direction, I have to disclose it. The political landscape here is, I mentioned how scope 3 sort of bumps up against potentially the SEC statutory authority. We at Ceres would argue it does not, and that's a whole other conversation. But the point is, opponents of the rule more broadly have sort of seized on scope 3 as a very, politically salient talking point about the burden that scope 3 reporting might pose on, small family farms, for instance, and small businesses. And so, opponents of the rule have definitely found a foothold in Congress with Republicans as well as moderate Democrats, and generally speaking, the SEC has to be responsive to the feedback they get in the comment file for any rule. And because this comment file is so robust, they have to account for the controversy around that provision. But also, the slated timetable for SEC finalization of this rule is, October, but that really just means that, SEC works with OMB on their unified rulemaking agenda and basically bucket all of their rules into either April or October at the end of, Q2 or Q4 on the government fiscal year. And so that really just means that they are moving as quickly as they can to hopefully finalize and adopt this rule by the end of, calendar year 2023, because as we get into an election year next year, the last thing anybody wants is for this rule to drag out and really become a political talking point more than it already has. And then finally, there's the outlook for litigation, and it's basically a foregone conclusion that the SEC will be sued when it finalizes and adopts this rule, hopefully soon. So I think there are questions of, who will the litigants be? And I think we can definitely expect lawsuits from Republican state attorneys general. That much, has happened basically with every SEC rulemaking here. And I know that they're primed to do so again. But then there's the question of where industry lands and certain trade associations. And I think one thing that the California laws really help is that if so many companies are already, obliged to provide this information in another jurisdiction like California or Europe, which, sort of like California is extraterritorial in its reach, you don't have to be headquartered there or listed in Europe. It's basically a revenue threshold like California. And so with so many companies impacted by other mandatory disclosure regimes, does that sort of bring industry back to the table a bit on the SEC rule and, make them reconsider whether opposition to elements like, scope 1 through 3 emissions reporting is worth really, getting in a drag out fight with the SEC about when the rest of the world is already there. And so that is the outlook. The SEC is certainly considering what they will be able to defend in the litigation phase. There may be major questions, doctrine challenges as to whether, Congress can even delegate the rulemaking authority to an agency on such a major question. There's First Amendment compelled speech challenges that might come up. And so, the SEC has to be responsive to the comment file, consider what they will face in the litigation phase, and finally, get to 3 votes among the Democratic members of the commission. And so that's sort of the phase where we are now. The details are being hammered out, and we hope to see a final rule soon. But, the Chair Gensler has to be responsive to the comment file and the concerns that have been identified, while also retaining key provisions that other Democratic commissioners have been vocal in their support of. So that is where we stand on SEC. And now we can go to the next slide.
Thanks, Jake. And I think we'll have Sarah join us, and the two of you can talk a little bit about next steps in the implementation process.
That sounds great. So I will start with just implementation guidance. As you can see here, SB 253, the emissions disclosure bill, CARB is required to develop and adopt regulations for these emissions disclosures and contract with a reporting organization, and then adopt regulations for the administrative penalties. And all of these regulations, per the enacted law, have to be finalized by the start of 2025. So CARB has next year to work this out. And then SB 261 is a little bit less set in stone, but CARB will again contract with a climate organization, adopt specific regulations for implementation. And the timeline will probably be something similar. We're not really looking at a drawn out process. This all has to happen fairly quickly. So one point to make is the budget aspect of this. CARB has put in a budget change proposal, essentially a budgetary request for funding for these bills, and we'll see details on those requests in Governor Newsom's January 10th budget. The thing is that those budget change proposals apply to the upcoming budgetary year, and so that funding would probably be available to start implementation in July of 2024. So with only 1 year to get these details right on the implementation side, it's really important that CARB has all the time it needs to develop these regulations. And so we're really hopeful that CARB can find creative pathways within their current budget to begin implementation sooner and not, restrict themselves to half of next year. And so that would require sort of shuffling funding around and finding the capacity to begin the implementation process. And then there's the question of the cleanup legislation. And as Senator Weiner mentioned, the question here is really, what will the scope of any follow-up legislation be? In his signing messages for both of the bills, Governor Newsom expressed some concern specifically about implementation deadlines that fall short of what CARB usually uses for its implementation of regulations. So we realize that the timeline for reporting is accelerated, and we think that is necessary to align California with other climate disclosure regimes globally and in the United States. But with the governor set to work with both senators' offices and the rest of the legislature to address concerns in this cleanup legislation that has been hinted at, that is the big outstanding question. There could be very surgical adjustments to the bills to address specific concerns that segments of industry may have had. Or, would other segments of industry view cleanup legislation as an opportunity to revisit, really core provisions of these bills? And so that is something that Ceres is going to remain closely engaged in on the legislative side, and we'll also be working with CARB to try and ensure they have the capacity they need to begin the regulatory implementation process. So I'll turn it back over to Sarah as we go to the next slide.
Thanks, Jake. Yeah, I wanted to briefly touch on future opportunities for corporate engagement and really want to emphasize, I think as you heard both senators speak to, we really think that continued business engagement will be critical for successful implementation of both of these bills. Not only will CARB be leaning on stakeholder input throughout that implementation process for info on best practices and what you all are already doing, as both senators referred to, there was significant opposition all throughout this legislative process that we expect to continue in the coming years. So there's just a great deal of value in having corporate leaders, both publicly and privately, sharing A, how feasible this reporting is, B, how you're already doing it, and C, what that actually looks like day to day and how those practices can be integrated into California to not reinvent the wheel. So with that, Ceres plans on continuing to cultivate and coordinate corporate engagement, really focused on 3 main areas of the California government. So really, I guess, all 3 main areas of government. So we'll start, with CARB with that implementation process in 2024. We'll be focused on bringing the corporate voice and to engage with the public comment period process, public hearings, as well as making sure that CARB board members and staff are hearing directly from the corporate perspective. Throughout the legislative session, again, depending on where that cleanup bill process goes, corporate engagement will again be really valuable for combating opposition narratives and misinformation, while also informing, the ways in which the core of the bills as passed need to stay as true as possible. There will also be that ongoing budget advocacy to ensure that the funding is available and maintained for the implementation process on schedule. And finally, we know it will be valuable for the Newsom administration and the governor to be hearing directly from leading corporations. We heard the governor state directly in his remarks at Climate Week that leadership by Salesforce and Apple and other leading businesses who took that public stance was valuable for him to hear from. So we know that will be also valuable going into this next year. So our Ceres team plans on staying in contact with folks across all levels of California government, and working closely with both senators, and we'll consistently report back to you on what we're hearing, and we'll be sure to share opportunities for engagement, again, both public and private, as they emerge. So I know we have just a little bit of time left, but Allie, I want to pivot to you if there are any questions we want to address.
Yes, thank you so much, both of you, for your just robust guidance and support for folks as we move forward. But there have been a couple questions in particular about what level folks should be reporting at. If they're a global company, are they reporting at the US level? And if they're a US company, are they reporting at the California level? So what kind of level should they be reporting at and thinking about emissions-wise?
Sarah, I can address that briefly if that works. Yeah, reporting is at the consolidated sort of parent company level. Obviously, your emissions do not discriminate whether they took place in California or elsewhere. And generally speaking, I think it would be a lot harder for companies if we were trying to do, California specific disclosure. This is actually something we're running into in Europe with their CSRD, where the first phase in is for companies' large EU subsidiaries, and then a few years later would be the consolidated parent company reporting. We've spoken with a lot of companies that plan to just start at the parent company level because they don't have their consolidation trees set up in a way that they can report for their French subsidiary or their Luxembourg subsidiary. It doesn't work that way. So to rearrange your financial reporting structure would be really burdensome, and that's not really whatever relief the EU is trying to provide. They did not do it with that. So we really tried to work with the California bill sponsors to ensure that we're presenting the least burden on these companies and making sure that reporting is sort of consistent with what they're used to doing from a financial and general consolidation perspective.
Great. Jake, I think this may be another question for you, just around scope 3. And obviously this is, some of this will be determined in the final rulemaking by CARB, but what categories of scope 3 will be required for SB 253? And then just, thoughts around the use of estimates, the timing, to what degree will modeling versus measurement be acceptable for supplier estimates in particular? So I tried to bundle a few questions in there. I don't expect you necessarily to get to all of them.
Sure. So regulatory implementation is crucial here because the legislation doesn't really spell this out in detail, but because of the reliance on the greenhouse gas protocol, we sort of know where, implementation, what direction it should head in. Greenhouse gas protocol definitely gives companies leeway to, ignore insignificant sources of emissions within scope 3. It says that companies need to account for all scope 3 emissions and justify any exclusions. And so companies that can, exclude emissions that are not material to them can justify them as such. And, these 15 categories of scope 3 provide companies with a uniform framework to organize their activities within their value chains. But there are sort of minimum boundaries identified within the greenhouse gas protocol, which tries to ensure that major activities are included and insignificant emissions are disregarded. So, in accordance with the greenhouse gas protocol, that's what we would hope to see with the final regulation. And then just in terms of reliance on estimates and averages, I mean, this has been a large source of sort of misinformation with the SEC rule as well. And companies do not need to gather granular data from all or really any of their suppliers. The greenhouse gas protocol scope 3 standard allows for the use of both secondary and primary data to calculate these emissions. And so secondary data relies on industry averages, financial data, other proxy data. So, the greenhouse gas protocol recommends that companies start with scope 3 screening to identify their hotspots and then really target those hotspots as well as any sort of low-hanging fruit where the data exists and is readily accessible to begin reporting. But, we would not expect a large food and beverage company, for instance, to go to hundreds of farms and demand data from each of them. it's at their discretion whether to do so, but it would really not be a sensible way of doing this cost effectively for the reporting company.
Thanks so much, Jake. And somehow we're at 4 o'clock. We had so many more questions. I want to just go to the slide deck really quickly. And of course, thank Jake and Sarah for their time. And of course, our other speakers, Chelsea and Senator Weiner and Senator Stern. If folks can scan the QR code here to access the survey and provide feedback, there's also a link here in the chat for you. We can jump to the next slide. For those of you who are interested in our broader efforts around protecting the freedom to invest, please feel free to visit our website, freedomtoinvest.org, about our broader work to protect the freedom to invest responsibility at the state and federal level. And then we can jump to a quick slide about some of our latest research and just invite you to go to ceres.org/reports to see some of our latest work. And finally, I'm going to pull up the last slide with Jake and Sarah's contact information. These two folks will be your resources moving forward. As you can imagine, we've got a lot of work to do ahead. And as we tried to outline, the Ceres team will be fully engaged every step of the way. We're eager for your collaboration and support. So please feel free to be in touch with Jake and Sarah or anyone on the Ceres team. We are so grateful to have partnered with so many of you in the passage of SB 253 and 261, and lots more to do to implement these groundbreaking laws. So thank you so much for your time and have a wonderful afternoon.